This week, the Supreme Court begins its next term. I thought it was important to review some of the results of last term's decisions, particularly those that are related to employment matters. The first one is Obergefell v. Hodges. This has been widely publicized, and as a result of this case, the Supreme Court ruled that same-sex marriages are afforded the same benefits and treatment under the law as traditional marriage. So what this means to employers: first of all, we cannot consider marital status as an issue when interviewing, and when we have same-sex couples, either who currently work for us or who come to work for us, those individuals are eligible for the very same benefits as a traditional married couple. The next case, which has also received some publicity, is Abercrombie and Fitch versus the EEOC. The EEOC filed a suit against Abercrombie and Fitch. A local store in Tulsa, Oklahoma, had an applicant who was wearing a hijab, which is a traditional headdress for Muslim women. She did not ask for accommodation for wearing her hijab, yet the employer denied her eligibility for employment based on her wearing the hijab. The ruling from the Supreme Court is that an applicant or employee does not have to specifically request a religious accommodation, especially when the accommodation is very obvious. So how the Abercrombie hiring manager should have handled it is provided a copy of the dress code to the applicant and asked her if there was any reason that she could not comply with that dress code. The final case that has some significant employment implications is Young versus UPS. Young was a pregnant employee at the time at UPS, and her doctor restricted her lifting. The employer, UPS, denied an accommodation for the lifting request and put her on unpaid leave, even though UPS had accommodated other employees for restrictions based on medical conditions. So the court ruled in Young's favor, however, remanded it to a lower court for settlement. What this means to employers is that we need to treat pregnancy as a medical condition, and accommodations, restrictions, etc. should be no different for pregnancy than they are for any other medical condition. In the next Tuesday tip, I'll review some trends regarding social media in the workplace.